Hi, my name is Alex Dolphin, and welcome back to another episode of Ex-Ante. Today we're going to discuss the case AT&T versus Concepcion. This case was heard in the Supreme Court of the United States in the year 2011. Let's go ahead and jump into the facts of the case. So the Concepcions had signed a phone plan with AT&T, and they basically got a free phone, but they had to pay sales tax on the phone. So you can imagine when you sign up with a new phone carrier, oftentimes they'll give you a new phone, but you still have to pay the sales tax. So they said that they alleged fraud on AT&T's part because the phone really wasn't free. They had to pay the sales tax. It was a $30 claim. Now, there was a contract that the Concepcion signed with AT&T when they began their phone service agreement. And in this contract, there was an arbitration clause. And this arbitration clause essentially said that if you're going to bring a claim against us, you need to arbitrate it. And you can't really be a part of a class action. You have to arbitrate all claims with us through an independent arbitrator, but you cannot sue us in a court. So the Concepcions end up becoming a part of a class action because of this $30 tax charge and saying it's fraudulent by AT&T. And they're challenging the arbitration clause in the contract. Now, the state of California, where this suit was originally brought, was sympathetic to the Concepcion's claim. Now, they were sympathetic because there was a rule in California. It was called the Discover Bank Rule. The Discover Bank Rule essentially said that you cannot waive your right to a class action. You cannot waive your right in a contract of adhesion to a class action, basically just by signing it away. Now, the Concepcions challenge the contract of adhesion, they call it, with AT&T, saying that this is essentially exactly what the court ruled in Discover, that you cannot force me to give away my right to be a part of a class action through this contract of adhesion. So we're going to challenge it. And the Supreme Court of California says, yeah, you know what? They can be a part of a class action, and they don't have to submit to your arbitration agreement. Now, the Supreme Court of California recognized that the AT&T arbitration agreement was fair. I mean, seemed like the arbitration process was good. But nevertheless, they said that this contract is unconscionable, is what they called it. Any waiver of your right to a class action is unconscionable. So the Supreme Court takes this up, and it's a divided court, a 5-4 ruling. The conservatives rule in favor of AT&T, and the liberal justices rule in favor of the Concepcions. Now, the ruling of the majority is interesting because it deals with the FAA, which is the Federal Arbitration Act. Now, the Federal Arbitration Act was passed in response to kind of a judicial rejection of arbitration as a whole. The purpose of the FAA is to ensure private arbitration agreements are enforced. So it's trying to incentivize parties to arbitrate. You could think the reason for that would be to keep claims out of court, keep expenses off the judicial system, and keep them between private parties and arbitrators. So you could see why Congress would want this. That's what they stated the purpose of the FAA was. So it's trying to encourage parties to arbitrate. Now, Section 2 of the FAA says that if someone signs a contract that could be invalidated for unconscionability, duress, fraud, that person doesn't have to arbitrate. So the question before the court is, California law says that this contract is unconscionable, but the FAA is trying to promote arbitration. So should we allow the federal government and the FAA to preempt the state law of California that says contracts of adhesions with class action waivers are unconscionable? And the court ultimately says that, yep, that's the case. The FAA and its stated purpose to promote and incentivize parties to arbitrate preempts California from being able to say that this law, from being able to say that the contract between the Concepcions and AT&T is unconscionable. So the FAA preempts California state law. Now, the dissent makes an argument that the FAA should not preempt this, and Section 2 should allow California to strike down this contract of adhesion and not force the Concepcions to arbitrate. So they're saying that essentially if you allow the FAA, if you allow AT&T's arbitration agreement to be enforced, that will be the death of consumer class actions altogether, because everyone will just put in a boilerplate arbitration agreement in their contract of adhesion, and people will sign that and they won't be able to be a part of a class action. So they were really focusing, the dissent was, on how this would dismantle consumer class actions as a whole. So it's an interesting case. It certainly is something to think about. On one hand, you have the freedom of parties to contract, the freedom of parties to set agreements before they go into business dealings. And on the other hand, you have AT&T, you have the Concepcions wanting to get out of a contract of adhesion. And should the FAA really preempt state law here? Should California be able to say what's unconscionable? And should the FAA just accept what a state says is unconscionable? So there's a lot of things at play here. There's class actions, there's federalism as a whole, and preemption. And that's what makes it such a complicated case. But what critics have said of this case is that it is the death of the consumer class action as a whole, because every single attorney, every single in-house corporate counsel is going to put in a boilerplate arbitration agreement to try and avoid these class actions in the future. So something to think about. Thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.